Hey guys, and welcome to today's video. Today, we have 3 videos to cover, with a much anticipated update from the Lindsey Duneske files, as she goes head to head against a true no-nonsense judge, Judge Washington. But before we begin, I'd like to thank today's sponsor, Chapter. Most people who are on Medicare end up paying hundreds, if not thousands of dollars a year because they picked the wrong Medicare plan. Now you can't really blame them, as they get steered into plans that aren't beneficial to them by greedy brokers who are motivated by money and not help. And that's why I chose to partner with Chapter. They started their company because their parents fell victim to this money-sucking strategy, and they decided enough was enough. When you call Chapter, you're going to speak to a real person who's going to walk you through all the plans available to find the right one for you. And best of all, the call is completely free. With Christmas around the corner and the average senior saving over $1,000 per year, this is a perfect time to put some money back in your own pocket. So give them a call at the number on screen or visit them at the link in the description and let a real human being review all the plans available to see if there's some money to be saved or if you already have the best plan for you. Thank you once again to Chapter for sponsoring this video. We're going to start with my favorite Karen of all time, Lindsey Duneske. So let's begin.
We're back on the record in the case of the state of Michigan versus Lindsey Duneske. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there. Ms. Moeller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
They do, Your Honor. I received those filings were sent to the court, and just now realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is the chief prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice to agent and notice to principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them because I didn't know which one would be on the case today.
Get the fuck out of here with all that sovereign citizen, notice to agent is notice to principal bullshit. That might work in whatever delusional world you woke up in this morning, but in reality, you have to serve the right person for it to actually count.
Ms. Woods?
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right. So first of all, Ms. Duneske has counsel. So whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleadings should come through her counsel. And
yeah, they refused to file it. So
ma'am, Ma'am, I didn't
Oh,
say
I'm
anything
sorry.
to you.
I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So
They
that's
don't
the,
have to be though,
ma'am, I
which
just,
I put
they do.
on there.
Ma'am, if you speak up one more time, you're gonna be held in contempt of court.
But I thought this was my hearing. I
Ma'am,
should be able to
ma'am,
speak on my
all
own
right,
behalf.
you're not. You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's gonna find you in contempt of court, and I'm gonna give you 15 days. So please stop talking. Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Mueller, what is your position? I haven't heard anything from you today, because she actually
Yeah.
has.
Thank you, Your Honor. Ms. Duneske and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Duneske did file these motions. And so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Duneske does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Dineski, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not
and the
automatic.
Constitution.
It is, ma'am,
Yes.
it is not automatic. So first
I mean,
of
the
all,
Sixth
ma'am,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under the
No,
Sixth
I heard
Amendment.
you. No, nope, nope, stop talking. So look, this is the way it's gonna work. I'm gonna give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional because I was the victim in the case and
All
falsely
right, I
arrested.
think what I'm going to do is refer her to make sure she's competent. Because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD.
Well, then you're seeing a psychiatrist for the wrong reason, Karen.
So if you would like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my rights, that's a violation of Scheer versus Cullen. All I'm doing is asserting my right to represent myself.
Referred for competency. We'll prepare an order so she can be evaluated so we can
Well, I
determine.
object to that. I object
You
to the
can object
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done. Do you
But why?
understand?
But you have to say that there has to be a reason. There has to be a cause for it. And I have a right to know why you are forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I'm supposed to
Well,
not have my
referring you
right.
for competency. You need to stop talking. And if you don't participate, I'm gonna put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify? And if
No,
he's not,
that is not
well,
how that works. And see, you don't
I
know
thought
anything about this, and that's why you shouldn't be representing yourself. But
I
you
did. The
understand
preliminary
you
exam
can
was supposed
only
to have
comprehend it.
witnesses.
This is not a preliminary examination, ma'am.
Oh, I was told, I thought that's what that was. I was just under the impression it was a
Refer for
preliminary.
competency, and I'm gonna schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any
Well, I
different.
don't have any way to get there. I live very far away from where this is
Then
now.
I think when you get picked up and you're required to come here by police, then you'll have a way to
But
get here.
why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And
That
that's
is
a
not what's
violation
going
of my
on.
rights.
Okay, Ms. Duneske, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will
Well,
be
I'm going to be
arrested.
filing with the Court of Appeals on this
Go ahead,
and the
ma'am.
Court of Claims because this
Thank
is not
you.
okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
Okay, well,
I'm
like I said,
done.
I'm going to be objecting to.
All right.
Alright, so it looks like Judge Washington has had about as much Lindsey Duneske as she can handle in one day. Nevertheless, it looks like her case will be progressing forward, so we should have future updates coming sooner than later. Now we head to another boss of a judge, Judge Simmons, as she had two morons on one docket yesterday.
On the record in the matter of credit acceptance versus Ashley Brown, 22-013536GC. Appearance, please.
Good afternoon, Judge. Francesca Serby for plaintiff P87205.
Okay, you're Ashley Brown.
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice of that.
And why would they give you a notice of garnishment? They notify your employer and the IRS, but they are under no obligation to notify you that they are notifying them.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the
Yes.
writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, her admitting in court that she got it. So a plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rule to notify me to, I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand, I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So the court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection, and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with, you're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is, you said that it was not issued, or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak. I'm sorry.
That's correct. Yes.
So when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like, I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. Like I mean, how am I supposed to respond to a garnishment if I don't have this, if I wasn't served?
Again, they are under no obligation to serve you for the garnishment. They served you for your initial lawsuit, and just like a lot of other people that we see on here, you only decided to take it seriously once they started taking money out of your paycheck.
Ma'am, you were served with the lawsuit in this matter, correct? And then you appeared before me back in December 1st, 2022. There was a joint pretrial statement that was completed. After that, you received your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You failed to appear. Default judgment entered against you.
I did not get notice is what I'm saying.
You failed to appear. You knew you were being sued. You were properly on notice that you were being sued, and the court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed. So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, once you fail to appear, a default judgment entered against you, and the court then sent a notice of a default judgment to that same address.
Did not receive that.
So the court itself sent multiple notices to the address on file notifying you of A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside. But you never did that, and that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since October 12th, 2022.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if they was lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't understand, like I said, how I'm supposed to respond, because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because, like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notification sent to me. How am I ever going to? I mean, how am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.
Well, technically, your job received the notice, since that's who they sent it to, not you. You were just the employee who happened to be responsible for opening the mail that day, and you intercepted that piece.
I don't know what you mean. How are you supposed to respond to a garnishment? This
Because,
is
but just like with this objection, like I'm
you
objecting to it, I'm responding to it. I did not receive notice of those prior things, and I've done
correct.
research
I
on this company.
recognize
This is
you're
this is not the
objecting
first
to
time
the
they've done stuff
garnishment.
like this.
Right, but I recognize you're objecting to the garnishment, but you're not providing the court with a objection that the court can consider. The court rule tells you what objections you can use. There are no such thing. There's no such thing as a hearing. There's no such thing as a hearing for a writ of garnishment. You don't
I
get a
was
hearing for
referring to
that.
the hearing, like I stated, that was the judgment hearing. I did not receive notice of that hearing. That's the
So the
hearing I was
court
referring
that
to.
okay, that
Because if
same
I
court
had
rule that
received
you're
notice
talking,
of the judgment
ma'am,
hearing, I would have
ma'am, you cannot
appeared.
continue to talk over me. What I'm telling you is that that same court rule tells you that you cannot use an objection to garnishment to attack the underlying judgment, which is what you're trying to do.
And I understand that, but what other premise can I go on if I don't have any notices? If I had gotten those notices, I could have objected earlier. That's my
Yeah,
whole
what I'm
thing.
telling you, you cannot object to a garnishment so that you can attack the underlying judgment. You're saying the reason why you're objecting is because you did not get notice of the hearing in which you got a judgment for.
But
The
it says
court
that they
rule
have to
says you
serve you
can't
with
do
these
that.
garnishments. It
No,
says
the
that
court rule says you can't do that. It says that you can't do that.
so there are no rules saying that they have to serve you with the garnishment. Is that what you're saying?
It says the garnishment has to be properly issued, and it was.
But I wasn't served it, is what I'm saying. So how was it
In that
properly issued?
they don't have to serve you with the garnishment. They have to serve your employer.
Okay, so I don't understand then how somebody is supposed to respond if they don't have the information.
No, you were supposed to respond to the lawsuit, not the garnishment.
Ma'am, and I have already stated I did not even receive a notice for the second hearing.
And like the judge said, why did it take you 3 years to finally respond? And why did you decide to respond coincidentally at the same time the garnishment was supposed to start?
But you can't use you can't object to the garnishment now.
We wouldn't be here though if
The court rule is very
if I had
clear.
received that
The
notice.
court rule is very clear. You cannot object to the garnishment to now attack the underlying judgment. Do you understand that part?
I understand that, but I'm saying if I
So why
didn't
do you
receive
keep
notice about the
repeating that
initial
then?
hearing,
Why do
then
you keep repeating the same thing?
because I'm trying to get you to understand that it doesn't make sense to say that I can't attack the
I
garnishment if I was
don't
never
have an
properly
issue with the
notified about the initial
understanding.
hearing. There
I
wouldn't
don't
be a
have it.
garnishment if I had
It's
been
not
notified.
me. I'm gonna terminate this hearing if you don't let me explain this the last time. I don't have the issue of the misunderstanding. I know the court rule very well. The court rule very clearly states you cannot file a motion to object to a garnishment because you want to now argue that you missed a court date or you didn't get notice that had to do with the judgment. That's what the court rule says. So you are trying to say that you didn't get notice of the court date that you were supposed to appear for back in March of 2023. The court rule says you can't use an objection to garnishment to do that. I didn't make the court rule, man. That's just what the court rule says. Do you understand that?
Yes.
So
Judge, can plaintiff respond?
You have not provided the court with a reason under the law that I can grant your request to object to the garnishment. Yes, ma'am, you can respond.
Okay, just to correct the record, Your Honor, it was actually a summary disposition judgment that was entered in 2023, and it was also entered pursuant to the notice of 7-day rule for entry of the order. So defendant had notice to appear for that hearing through plaintiff's notice of a hearing. They had an opportunity to object to the entry of the summary disposition judgment. They didn't file a response to plaintiff's motion for summary disposition judgment. And as Your Honor had already stated, it's not a proper objection to writ for garnishment when you're attacking the validity of the underlying judgment under the court rules. So it's plaintiff would ask that you deny the objection is invalid and appreciate that you've done that.
I'm trying to explain so that the Ms. Brown can understand her concern, because I'm not saying that there's no other avenue for you to go and try to figure out what happened with your notice, or according to what they filed, you were served with a notice for your date to appear in court. And outside of that, you knew you were being sued. And so when you appeared in my court in 2022, there shouldn't be a next appearance 3 days later, or 3 years later, that is. You should have appeared at some point wondering what was going on with your case, because you knew you were being sued. And they had served you with discovery. They had served you with a summary judgment motion, which the court told you when you saw us would have a deadline date. And so we advised you of that when you were last here in 2022. When you didn't respond until this objection. And you can't now attack the judgment because the court rule says you can't do it this way. And so I have to deny your motion, okay? Okay, so if you want to, I don't know what the balance is on the debt, and I know you said that you had some other garnishments that took place. You could try to meet with Ms. Servey and see if you all can work something out and maybe enter an installment payment agreement or another kind of settlement agreement that will prevent them from trying to garnish your wages. So if that's what you want to do. I could put you in a meeting room now for that purpose, to see if you can come up to another arrangement so that they won't be garnishing your wages.
Okay, let's do that.
Okay.
I don't know why they would ever want to do that with her, unless she is going to agree to pay higher than what the garnishment is already taking out. Alright, so now we head to another hearing on Judge Simmons' same docket.
And ma'am, your name?
Andrea Will.
Okay, today was the date that was scheduled for hearing. This is for non-payment of rent. My understanding is that you did not come to a resolution.
That's correct, Your Honor.
Okay, so ma'am, you believe that you have a lawful reason to withhold the rent?
I can't make an agreement now. I'm waiting for DHS to send me information, and
So your information about what?
I don't.
Ma'am, I asked you a very specific question.
I'm trying to answer.
No, you didn't. Do you have a lawful reason to withhold the rent?
Not all the rent, but the court fees and the attorney fees and all that. And
What's the
plus, I'm
lawful-
trying to get help.
What is the lawful reason?
The lawful reason is because I told her I'd be there that day to pay both months. I got robbed and beat in the head on the riverfront the month before I got behind. I went in the office that day,
Well,
so I
those
was
don't
there
quali-
that afternoon, and she
Those are
filed.
unfortunate reasons, but they're not lawful reasons. So a
But-
lawful reason to withhold the rent would be like,
And I just say, rent.
ma'am, the lawful reason will be something like there was, you were illegally locked out of the property, or there was a condition with the property that infringe on your ability to enjoy or stay in the property, like a health condition in there. Not what you're talking about is personal.
No, it was the riverfront part of the property.
Excuse me?
Is the riverfront where it happened part of the property?
No.
Well, there is another reason. There are other reasons. Yes.
Okay, well, I asked you what the lawful reason. I only want
I don't know
lawful
what,
reason.
I don't know the law you guys do, but I knew that I had to file for help by the 5 days after the last one, and I did. And when I got here, I haven't gotten anything from DHS yet responding to me yet. When
Okay,
I got here, I realized I didn't
so
have my phone, so I can't.
you're
prove
saying
it.
that you applied for
Yeah.
help with DHS,
Yes.
but the video said if you applied, you had to file proof within 5 days.
I called the court though, and they said
Where's
to
the
bring it when I
proof
came
that you filed?
here.
Oh, did you get paid more than
And
$200?
They weren't even here. They weren't even here.
Do you get paid more than $200 to be here?
Yeah.
I sure hope you do.
They were not even
Do you
here.
know how much his hourly rate is?
Why are you saying I don't have to pay, and then you're saying that?
I didn't say you didn't
pay
have to
now?
pay. There's a statutory amount if you are evicted or there's a judgment against you, there's a statutory amount that's imposed, but I can guarantee you it only covers his gas money.
They haven't done anything for me.
They're not representing you.
But you know what?
They represent the landlord.
It should be unfair. She filed it $288.
I don't know what you're talking about. That has nothing to do with this case.
Why? She's part of the case.
Who's
I
she?
don't understand.
Who
The
is she?
manager of the apartments.
They are suing you.
I know.
The
And they
attorney
shouldn't
does
have,
not
because I told her
represent
I'd be there
you.
that day to pay it, and she filed at 3 o'clock in the afternoon with the attorney.
The
Why?
attorney
So
does not represent you, ma'am.
I didn't say he did, but why am I paying him then?
When you're ordered to pay attorney fees for the other side, you are paying them back for the money that they paid to their attorney, not paying the attorneys directly, thus becoming one of their clients.
When did you pay him?
Last time I was brought to court, they made me pay $185
In this
court
case,
fees.
or a
No,
different
the
eviction?
first one.
We're not talking,
Here,
we are
same
not talking
apartment.
about any eviction other than the one you're
Same
here for
apartment.
today.
I didn't, wasn't
Judgment for the
evicted.
plaintiff.
I wasn't evicted.
I'm not gonna deal with
I
this.
want a hearing. I want to try.
This was a hearing, but you can't comply with the hearing because you think you're gonna talk over me and you're gonna.
I'm not wanting
And
to
you're not
understand
following-
why. I don't understand what I should do until I know the facts, because I mean, why? I don't know if I approve of what I owe, because I don't know what I owe when they check on other charges
You
later.
owe $829.54 plus court cost of $178.54 for a total amount of $1,008.08. You need to pay that in full or you're going to vacate the property by Monday, September 29th, 2025, okay?
I filed for help, so what do I do about that?
You need to, we advised you of your rights when you came last time. We said if you had proof that you had a promise to pay
I
from
do.
an agency,
I left it.
talk over me one more time, I won't bother to
Sorry.
explain it.
I have
If
anxiety.
talk over,
ma'am, I'm
okay,
sorry.
well then, if you know what helps your anxiety,
It's not this.
to relax and calm down. So just listen. He said if you have proof that you had a promise to pay from an agency, you need to file that proof within 5 business days.
They told me I had to apply within 5 business days.
That's not what it says,
That's what they said. It was my first Zoom thing.
ma'am. Do you know how many times a week I listen to that video?
She said 5 days.
It says you need to, no, it says you need to provide proof within 5 business days, not apply within 5 business days.
I did.
And you've not even gotten anything that said that they were going to pay the past due.
I
amount.
haven't gotten anything from them yet.
Correct. So you need, the judgment's going to enter as of today because you have not been able to come to a resolution. If you do get proof or a promise to pay, you can bring that to the court. And then that way, maybe that the court can withhold the writ if you move to the writ date, or maybe they'll give you an extension if they're gonna get a promise to pay. But you gotta get the past due rent paid.
So didn't want to do that until I knew what the total amount was. Because
The
for the first
total is
paperwork,
$1,008.
but I haven't gotten anything in writing from them yet that that's what it was. I got a 288.
You got a 288?
Yeah,
What do you
when
mean?
they filed, that's how much the amount said.
Is that how much your monthly rent
It
is?
was, it was plus some late fees, I think.
288
44,
is your monthly rent?
44.
244 plus late fees? Is that accurate, Mr. Garlinghouse?
Yes, Your Honor. And at
Okay.
the time of filing, it was 311.54 that was owed.
That was what
I got-
what
And that was
month?
back in July.
It's September, man. We're almost in October.
I haven't gotten anything else from them yet since I filed 2 or 3 weeks ago with DHS.
I don't know why you thought you was gonna get something else
What do you
from your
mean?
landlord. What else were they?
Because
You know
showing
your,
the total amount that I owe.
you know your rent is due every month.
I know that. And
Have
I
you
was
been
gonna pay
paying
them
it?
both months on the beginning of last month, but she filed with the attorney, so I decided not to do anything until I found out what the total amount was due, because if I paid anything, then DHS might turn me down saying, you already paid it, we're not helping you.
If you have the money, then use your money. I don't know what it is with all these people wanting handouts, even when they don't need them, and putting themselves in a position to be evicted and to lose their government housing to begin with, all because they just don't want to spend their own money.
That's what I was told by somebody else.
I don't know who told you that, but I do know that you owe $1,008.08 and you gotta pay that or vacate by the September 29th date. If DHS does give you a promise to pay, you should bring that down to the court, take it to the clerk's office, and then we'll see if we can hold off on a writ date for you, okay?
Okay, can I ask a question?
Yes.
Do you do a lot of the Section 8?
Do I deal with
I
sec-
just wondered if, because I talked to them on Zoom, I had a breakout session with the attorney and the manager, and I said, I don't know what's going on, maybe it's not a good fit. Do you have to be on Section 8 for a year to be able to transfer to another, get a voucher to another place?
Well, if you're on Section 8 and you have a voucher, I think you have a lease that you have to comply with, but I know you can't get an eviction on your record if you have Section 8, because that can impact your Section 8.
Right, But I remember the attorney broke up, said if they forgive the cost if I did, I just didn't.
I don't know. So you are on Section 8?
I am.
So then you should have been trying to work out an agreement with them so that you can keep your Section 8, because if you
She
get
took
a
me out of
judge.
her office when I talked to her, and she filed, I went down to their office and told them I was paying that day, and she filed at 3 o'clock in the afternoon. That's why I was upset.
Okay, but
She didn't
if,
wait and
if
told
it-
everybody in the lobby
it
in
was
front of
late.
everybody.
if it was late, she doesn't have to wait till 3. It was,
She said, I went in the office and said I would be down there that day. And she filed before I got there that day. There was another person in the office that gave her that information. So it was like she
okay,
retaliated.
but you went down and paid your rent?
I wouldn't after she filed with the attorney.
If you had to pay the rent,
I had it. I was going to,
she could have dismissed it if you had to pay the rent.
but she did it before I even had a chance.
Doesn't
and
matter.
I thought
If
she did it just to get attorney's fees from me again.
I
No,
can
it didn't
guarantee
make
you,
sense to
I
me.
can guarantee you, they're paying more than what you have
I
to pay
haven't seen the
attorney's
fees.
fees. It's
I haven't
costing them
seen or
money.
heard from those
It is
attorneys.
costing money for them to hire an attorney. And the statutory attorney fee that they're imposing upon you is not the cost that they're expending to hire legal counsel.
Yeah, but I've never seen their legal counsel. How do I know they're doing that and not just giving
It
me
doesn't
paperwork?
matter. They're not representing you.
No, but you know what? They should show proof just as well, right?
They
If
know
I'm
they
paying
don't.
them-
No, they shouldn't.
If I'm paying them, they should.
You're not paying their attorney.
I was.
No, the court is imposing a statutory attorney fee because you required them to get an eviction. They're,
No, I didn't.
yes, you did. You didn't pay your rent.
I told her to be there by 5.
Okay, you're all
She
set,
filed at
ma'am.
3.
You can be
So
excused.
that's ridiculous. I'm sorry. I don't mean to disrespect you. I really don't.
I
just
I
really-
can't help you I can't explain this anymore to you.
I don't understand. I'm
Okay,
sorry.
I get it. Then you need to go and seek counsel to get someone to explain it to you. And he is not your attorney, he is their attorney,
He's
okay?
not the one that, yeah, but not according to their paperwork on my filing, okay? So that's what I don't understand. That I've not been able to get them to respond to me or call me. I've tried to change the last court date to see my son one time, and he downtown to court at the same time. And I didn't.
I remember your pretrial, you were, I think, trying to see your son,
And then
but
they said
that
that,
has nothing to do with this case, ma'am.
well, the court tells me that the only person that could change that, the change of date was the attorney for them, and they didn't even try. And then they told me, no, we can't, when I was in the breakout room. So I don't trust someone like me. Who's right, the court or not?
They don't represent you, ma'am.
I'm saying he was right. He said he couldn't change the court date.
He couldn't change the court date. He
The
didn't
court's
say
the
it.
one that said that the only one that could change the court date is the attorney.
I'm the court.
The-
I didn't say that.
They said, no, I called the court. They
You
said the
called
only
the
one that
clerk's
can change it
office.
is their attorney.
You called the clerk's office.
Yes.
The clerk's office told you that if you want the court date changed, that you needed probably permission from them
Right,
so that you can request the court dates to be changed.
but they wouldn't respond.
They didn't want the court date changed. They want their money.
They didn't, they said they couldn't.
They don't have to.
Thank you, Your Honor.
You're welcome.
Alright guys, that's the end of today's video. Like I said earlier, Lindsey Duneske should have a few hearings coming up, so we should definitely be getting updates sooner than later. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.